Have you heard the saying, it's my way or the highway? Basically saying you can take what is being offered or you can leave. This ideology is the basis of this presentation in contract form. Hi, my name is Vernon Scott. For today's case, we will be talking about adhesion contracts or contracts of adhesion. First, I will give a little insight as to what exactly an adhesion contract is. An adhesion contract is a standardized contract which is imposed and drafted by the party of superior bargaining strength. It relegates to the subscribing party only the opportunity to adhere to the contract or reject it. In general, adhesion contracts are often enforceable, but in some cases, a court may find that the lack of negotiation renders such a contract unconscionable and unenforceable, particularly when it contains terms that are severe or detrimental to the non-drafting party. These were the circumstances in the case of Graham versus Scissortail Incorporated. As you see here, the case title, Bill Graham versus Scissortail Incorporated, the case citation, and the year the case was decided. The facts of this case are that Bill Graham, a promoter of musical concerts, contracted with C. Russell Bridges, also known as Leon Russell, and his wholly owned music corporation, Scissortail, Inc., for 4 concerts. Bridges and his corporation were members of a union for musical performers known as the American Federation of Musicians. With Scissortail being a member of this union, the contracts signed between Bill Graham and Russell Bridges were standard contracts for all union members, even though they were not labeled as so in this particular situation. After 2 of the 4 shows were completed, a disagreement arose about who should be responsible for any net losses incurred. With the dispute arising, Scissortail enlisted the services of another promoter to fulfill Graham's promoter job. In doing this, Graham viewed this as a breach of contract and wanted to file a lawsuit for this. However, as he was under contract with an AF of M union member, he must go through arbitration, with the arbitrator being appointed by the union. This resulted in Graham being ruled against in arbitration and owing Scissortail for any net losses from the shows he promoted. Graham appealed this and the ruling was reversed. What's the main issue here? In the case of Graham versus Scissortail Incorporated, is the contract provision of requiring arbitration of disputes before an AF of M arbitrator indicative of a contract of adhesion? If so, is it enforceable? The courts felt that with the provision of the AF of M arbitrator, the contract was not enforceable. Instead, the courts reversed the original ruling in favor of the parties finding a neutral arbitrator for the proceedings. The holding. The court held the arbitration agreement at issue failed to achieve the level of integrity because it designated Scissortail Inc.'s labor union as sole arbitrator. Rationale. The AF of M's contract disputes are designated to an arbitrator who, by reason of his relationship, status, and identity, is presumptively biased in favor of one party. It is for that reason that the adhesion contract, deemed unconscionable and unenforceable, was reversed, and Bill Graham was given the chance to go out and find neutral arbitrators to have the proceedings go on. In closing, I feel that the ruling made by the Supreme Court of California was correct in reversing the arbitrator's ruling, because I didn't feel it was fair with an arbitrator being appointed by the labor union that represented Scissortail Incorporated be over the proceedings. I feel they couldn't be impartial and give a fair judgment to Mr. Graham in this case. Thank you.